extensive articulations of their relative positions, it is clear that the issue of fair hearing has 5 distinct sub-issues, being A, whether the petitioner was afforded sufficient opportunity to present her case, B, whether the senators were given adequate time and opportunity to consider the matter, C, what is the probative value of the statements both during and after the fact by a section of the senators, so it should be 6. D, whether there were disruptions or disorder of a nature as to deny the petitioner a fair hearing. E, whether in the Senate proceedings the petitioner was subjected to discriminatory or unfair treatment. And F, whether there is evidence that there was a preconceived outcome and thus the hearing before the Senate was a sham. The question of whether the petitioner was afforded a sufficient opportunity to present her case requires an examination of both the individual milestones in the hearing process as well as an overall view of the entire Senate process. In both aspects, the petitioner has provided evidence in the form of the Hansard that shows that the procedural milestones were met and they were of a sufficiently proper nature as to insulate them from an adverse finding by this court. The petitioner may disagree with the overall outcome of those steps and how they connected as a whole, but the petitioner has not shown a deficiency in each or in all as a collective that would require this court's interference. Another aspect of the petitioner's argument is that she was only given 2 minutes to make a personal statement at the conclusion of the proceedings and that she did not get the chance to deliver it. However, the court's review of the Hansard and video recordings indicates that the Speaker of the Senate granted her the opportunity to speak. The uncertainty regarding whether she remained silent by choice or whether there was a technical issue with her microphone does not alter the fact that she was given the opportunity to address the Senate. Moreover, her legal counsel did not raise any objections during the proceedings, either regarding the time allocation or any technical difficulties. Courts have previously held that a party who fails to object to a procedural issue at the appropriate stage cannot later claim to have been denied a fair hearing. In Republic versus Public Procurement Administrative Review Board and another ex parte Gib Africa Limited and another 2012, the court ruled that a party who fails to raise an objection at the appropriate stage of proceedings cannot later claim to have been denied a fair hearing. Since the petitioner did not object at the time, and there is no evidence that she was prevented from speaking, the claim that her right to a personal statement was violated lacks merit. Similarly, the petitioner has failed to show that the senators did not have sufficient time and opportunity to consider the matter. The respondents and the interested parties who oppose the amended petition are correct in stating that it is not for this court to impose its own view on how much time should have been allocated or how the matters should have been laid before the senators, but rather to see if they meet the basic requirements of a fair hearing. I note that the impugned resolution process commenced substantively with the Senate's decision not to have a special committee hear the matter and prepare a report which would be voted on by the House, excuse me, but rather have the entire Senate sit as a committee of the whole House and vote as the special constitutional procedures applicable require. This, to my mind, meant that each senator who participated had sufficient time and opportunity to consider the matter. One of the petitioner's key complaints is that senators were only allocated 3 minutes each to debate the impeachment motion, which she argues was an insufficient amount of time. The petitioner has presented signing-in forms suggesting that some of the senators may have objected to the short debate time, as well as statements made thereafter about an alleged admission of insufficient time and opportunity by some of the senators. However, for such an argument to hold legal weight, the petitioner should have ensured that the senators who felt constrained by the debate time had sworn affidavits confirming that they were unable to effectively express their views and consider the matter and file them in these proceedings. Courts have consistently held that procedural fairness should be analyzed holistically rather than focusing on isolated aspects of a process. In JSC versus Mbalu Mutava and another 2015, the Court of Appeal emphasized this point. Applying this principle, this court finds that the limited debate time did not compromise the fairness of the proceedings, as the impeachment process did not involve a committee report requiring lengthy deliberations. Additionally, senators had access to the impeachment report beforehand and were given an opportunity to ask questions and deliberate before the proceedings. Therefore, the claim that the short debate time rendered the hearing unfair is not substantiated. The petitioner also argues that the impeachment proceedings were chaotic and disruptive, thereby affecting the fairness of the process. However, an examination of the petitioner's own video evidence, as well as the official Hansard, does not support the claim that the chaos was of such a nature that it negatively impacted the fairness of the hearing. Courts have previously ruled that not every procedural irregularity renders a process unfair. Only those that materially affect the fairness of the proceedings are considered grounds for judicial intervention. In Dry Associates Limited versus Capital Markets Authority and another 2012, the court held that not every procedural irregularity is fatal. Only those that cause substantial prejudice to a party's rights will justify the setting aside of a decision. In this case, the court has determined that while the proceedings may have been politically charged, there was no significant disruption that prevented the petitioner from presenting her case effectively. Therefore, the argument that procedural chaos rendered the hearing unfair is not supported by sufficient evidence. On the penultimate sub-issue, the question of gender discrimination and denial of equal treatment under the law, there can be no denying that, zooming out from the present case, we remain a nation that regrettably has not made the strides towards gender equality and promotion of the participation of women in governance that a nation of our democratic credentials should have made. There can be no denying the fact that despite all our other successes in constitutional implementation and deepening our democracy, the area of fostering inclusivity and diversity in political representation remains one in which we need to do much better as a country. It is difficult for women to successfully demonstrate gender bias and denial of equal protection of the law in the governance arena, because more often than not, these biases and discriminatory treatments are not brought out starkly by those who perpetrate them, but rather they are subtle yet significant actions, decisions, and omissions that create an unequal playing field for women. That being said, the petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings, or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner. Had the contrary been demonstrated to the required standard, then on this sub-issue of 7 main issues, this court would have had no hesitation in quashing the Senate's resolution. The final claims raised by the petitioner relate to the dating of the Gazette notice and the clerk of the Senate's letter, as well as the speed with which the Senate conducted the impeachment vote. The Senate contends that the Gazette notice and the clerk's letter were both dated 20th August 2024, despite the vote taking place on 21st August 2024, which she argues is a proof of a predetermined decision. Under Section 107 of the Evidence Act, the burden of proof is on the petitioner to establish that these documents indicate a premeditated decision rather than being the result of a typographical or clerical error or even a good faith mistake. The petitioner failed to provide evidence to refute the simpler explanation that the date discrepancy was a minor administrative oversight rather than the much more serious claim of a proof of a rigged or predetermined process. Similarly, the claim that the Senate rushed to conclude the impeachment or sat on non-gazetted days has not met the required threshold, as there is no requirement that the impeachment proceedings must last a specific duration. Courts have previously held that the expedited process is not inherently unconstitutional unless it is demonstrated that it deprived a party of an opportunity to be heard. In Republic versus Speaker of Nairobi City County Assembly and another ex parte Evans Kidero, 2017, the court held that an expedited process is not inherently unconstitutional unless it is shown that it deprived a party of an opportunity to be heard. The petitioner has not demonstrated how the Senate's action of expediting the hearing and determination of the matter before it deprived her of an opportunity to be heard or was indicative of a preconceived outcome. An analysis of all the applicable evidence demonstrates that the petitioner was accorded all the procedural safeguards necessary for a fair hearing, including the opportunity to present evidence, respond to both allegations as well as questions from the senators, oppose the county assembly's position, and make a final statement. Excuse me. The Senate proceedings followed standard parliamentary procedure, incorporating an opening statement, presentation of evidence, an opportunity for senators to ask questions, and a closing statement. The court has assessed the totality of the impeachment process and found that the petitioner was given ample opportunity to present her case and respond to allegations leveled against her. While the petitioner has pointed out certain aspects of the proceedings that she considers unfair, such as limited debate time, the opportunity to make a personal statement, the alleged chaotic nature of the proceedings, the timing of official communications, and the perceived haste in concluding the impeachment, none of these claims have been substantiated sufficiently to warrant a finding that her fair hearing rights were violated. Therefore, the Senate's impeachment process was procedurally sound and does not warrant judicial intervention on grounds of unfair hearing. Conclusion. Paragraph 133. Gubernatorial impeachment is an invaluable safeguard against impeachment of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another forum, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily courts would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March, 2025.